Mr. Munzur Hassan Obi, Executive Director, Center for Peace and Justice, BRAC University, and Chairperson, Action Aid Bangladesh, for his opening remarks.
Thank you very much, and good morning, everyone. A very warm welcome. Guest of honor and special guests, Your Excellencies, all other dignitaries, members of print and electronic media, distinguished guests, ladies and gentlemen. I also welcome those who are following us on Facebook live streaming. On behalf of my fellow conveners, I was tempted to say fellow conspirators, but fellow conveners, Professor Imtiaz Ahmed and Ms. Farah Kabir, it is my immense pleasure to welcome you all this morning and to thank you for making the time to attend this important seminar, which has been jointly organized by Action Aid Bangladesh, Center for Genocide Studies, and the Center for Peace and Justice. Today's seminar, Accountability, International Criminal Court, and the Rohingya Crisis, is about more than 1 million Rohingya refugees and their deportation from Myanmar to Bangladesh as a consequence of what a recent UK House of Commons report described as, I quote, deliberate, state-sanctioned, long-term ethnic cleansing of the Rohingya people. I repeat, deliberate, state-sanctioned, long-term ethnic cleansing of the Rohingya people. This is a report that came out from the House of Commons, I think, last month. The matter has now come before the International Criminal Courts at The Hague. On 7th May, a letter was sent to the ICC prosecutor to the government of Bangladesh seeking letters opinion on the issue of jurisdiction. The deadline is 11th June, another week from today. The ICC prosecutor has already very eloquently argued that the court has territorial jurisdiction due to the fact that the deportation of Rohingyas from Myanmar involved movement into Bangladesh, which is a party to the Rome Statute. We have three very distinguished guests who will be sharing their thoughts on this and other issues. We look forward to hearing from them. Let me end by citing from a recent article that I wrote, and I quote here. The government of Bangladesh has to be far-sighted in presenting its case to assist the ICC to advance international law and accountability. Given the fact that Bangladesh has already won the hearts and minds of millions of ordinary people by its unprecedented generosity and hospitality, Prime Minister Sheikh Hasina's government has to occupy the high moral ground, which they already do, and the hope is that they will continue to do so. Whatever outcome of the ICC process, history will record Bangladesh's desire for global peace and justice under the leadership of Prime Minister Hasina, if the letter and spirit of accountability is embodied in the response to be submitted by 11th June 2018. So I will not lengthen my opening welcome speech. I would like you all to hear what our guests have to say. So I again thank you for your presence and hope you will have a fruitful morning. And we also wait to hear from you when we have a question and answer session. Thank you very much.
Thank you, sir. Now I'd request Justice Syed Rifat Ahmed, sir, for his remarks. Sir.
The conveners of this seminar, the guest of honor, special guest, ladies and gentlemen, good morning. Taking a cue from the op-ed that was published several days ago, penned by Barrister Manzoor Hassan, I am tempted to begin by referring to the Constitution of the People's Republic of Bangladesh and take you to the very opening provisions in the form of the preamble to the Constitution that incorporates in emphatic terms an intent to make Bangladesh's full contribution towards international peace and cooperation in keeping with the progressive aspirations of mankind. That preambular provision finds specific content in Part 2 of the Constitution that incorporates what are known as the fundamental principles of state policy. They basically remain unenforceable through a court of law, but they nevertheless remain essential to the governance of Bangladesh as declared in Article 8.2. It is Article 25 of Part 2 that deserves mention here. And it states that the state of Bangladesh shall base its international relations on the principles of peaceful, inter alia, peaceful settlement of international disputes and respect for international law, and by subscription to the principles enunciated in the UN Charter. And it is on the basis of these principles that it is declared that Bangladesh shall extend support to oppressed peoples throughout the world, waging a just struggle against imperialism, colonialism, and racialism. The subscription to the UN Charter is significant for our purpose this morning, given that Article 2.3 of the UN Charter makes it imperative for all member states like Bangladesh to settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. The notion of settlement of international dispute by peaceful means gets further to be enunciated in Article 33.1 of the UN Charter. And it says that the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements or other peaceful means of their own choice. It is against that constitutional dispensation that this country today, and as of the 25th of August 2017, has seen and experienced more than 670,000 Rohingyas being driven out from Myanmar into its territory. About 50% of the Rohingya refugees are children, and an estimated several thousand of whom are unaccompanied and separated from their families. According to eyewitness accounts of the atrocities, the Myanmar army has been involved in the rape, murder, and significantly deportation of Rohingyas. The cross-border humanitarian crisis affecting the Rohingya population has been described as a textbook example of ethnic cleansing by the UN High Commissioner for Human Rights. Whether the perpetrators of these atrocities can be held accountable before the International Criminal Court, the ICC, remains a contentious issue, not least because the country in which the offenses have originated, Myanmar, is not a party to the Rome Statute, which established the ICC, and has not accepted ICC's jurisdiction under the statute by reference to Article 12.1. In my address today, I would like to set out an overview of the legal framework for the ICC's exercise of jurisdiction given such a scenario. On 17 July 1998, a conference of 160 states in Rome established the first treaty-based permanent international criminal court. The Rome Statute sets out the crimes falling within the jurisdiction of the ICC, the rules of procedure, and the mechanisms for states to cooperate with the ICC. Article 5 of the Rome Statute provides that the ICC has jurisdiction with regard to genocide, crimes against humanity, war crimes, and the crime of aggression. Crimes against humanity, interestingly, have been further defined in Article 7 to the statute to include, among others, the offenses of murder, extermination, and deportation. There are theoretically 4 ways in which the ICC may exercise jurisdiction over crimes committed by the Myanmar authorities. 1, through the reference by a state party of investigation by the ICC prosecutor. 3, by reference of the dispute by the UN Security Council to the ICC. And 4, by the acceptance of the ICC's jurisdiction by the state in question, which would be Myanmar, which seems to be pretty far-fetched under the circumstances. On the issue of reference by a state party, we come to Bangladesh as a state party, which may refer the matter to the Office of the Prosecutor for investigation by reading of Article 13A and Article 14 of the Rome Statute. Bangladesh ratified the Rome Statute in 2010 and has thus submitted itself to the jurisdiction of the ICC with regard to crimes referred to in Article 5 of the statute. Now, under Article 12.2 of the statute, the ICC may exercise its jurisdiction where A, the alleged perpetrator is a national of a state party, or B, where the crime was committed in the territory of the state party. It's the latter aspect, the territorial jurisdiction aspect of it, which the ICC is counting on at this point in time. In the present case, although the alleged perpetrators are not nationals of the state party, it may be plausibly argued that the offense in question have been partly committed in the territory of a state party, that is Bangladesh, and that therefore ICC has jurisdiction in respect of the offense in question. In the application under Regulation 46.3 before the pre-trial division of the ICC for a ruling on jurisdiction, the Office of the Prosecutor has argued that the offense of deportation, which requires victims to cross an international border, has been partly committed in the territory of Bangladesh. Article 12.2a of the statute provides that the ICC may exercise its jurisdiction if the conduct in question occurred on the territory of a state party. It would be prudent to draw your attention in this regard that there is an agreement or a consensus in international law that states have jurisdiction over crimes committed only partially on their territory. Here, one may invoke the notion of subjective territoriality, that is, when crimes are committed on a state's territory but concluded in another state, or the notion of objective territoriality, when crimes are committed on a state's territory being initiated elsewhere. It's the latter principle that is being invoked by the Office of the Prosecutor in this case. And the Office of the Prosecutor is of the view that since the conduct requirement is fulfilled if at least one element of the Article 5 crime is committed in the territory of a state party, the ICC may exercise jurisdiction under Article 12(2)(a), either if the originating party is a state party or if the receiving state is a state party. It is the latter which is true in this case, the receiving state being Bangladesh and a state party. In the present case, one of the constituent elements of the offense of deportation, that is, the crossing of an international border under compulsion, has taken place in the territory of Bangladesh. It may thus be argued, by relying on the objective territorial principle, that the conduct in question, that is deportation, occurred in Bangladesh, and that the ICC may exercise jurisdiction over any crime or deportation from Myanmar into Bangladesh. It should be borne in mind at this juncture that Article 12(2)(a) of the statute delegates the state parties sovereign powers to assert jurisdiction over Article 5 crimes to the International Criminal Court. As such, akin to a state's sovereign powers to assert jurisdiction over acts occurring in the territories of multiple states, the ICC too may exercise jurisdiction over offenses which originated in one state but were completed in another state. Furthermore, the law and practice of various states, including Bangladesh, show a willingness to exercise jurisdiction over crimes committed in only a part of their territory. For instance, Section 5 of the Prevention and Suppression of Human Trafficking Act 2012, a municipal law in Bangladesh, expressly recognizes the extraterritorial application of the said act. According to Section 5.2, the offense of human trafficking is deemed to have been committed in Bangladesh if it commences outside the territory of Bangladesh and is completed inside its territory. Thus, crimes which are committed only partly within Bangladesh are tried and punished under municipal law as if they had been committed within the territory of Bangladesh. But perhaps the most compelling argument for the exercise of jurisdiction by the ICC is that the Rohingya people were specifically and intentionally deported by the Myanmar authorities into the territory of Bangladesh. Not only is Bangladesh the receiving state of such refugees, but also its territory has been specifically targeted by the Myanmar authorities for commission of the cross-border crime of deportation. As such, the receiving state, and by extension, the ICC, has sufficient interest in the matter to assert its criminal jurisdiction over the crimes in question. Once it is established that the ICC has jurisdiction over the crime of deportation, Bangladesh may, as a state party to the Rome Statute, request the Office of the Prosecutor under Article 14 of the statute to carry out an investigation into such crimes. There have been numerous examples by referral of state parties in the past. In December 2003, Uganda referred to the prosecutor the situation with regard to the Lord's Resistance Army. In 2004, Congo and the Central African Republic referred to the prosecutor the offenses committed within their territories. In all three cases, investigations were commenced and arrest warrants duly issued against the alleged perpetrators. Secondly, even if the Bangladesh government does not make a request under Article 14, it is open for the prosecutor to act on its own initiative, i.e., proprio motu, under Article 15 of the statute to open an investigation into the matter. If the prosecutor is satisfied that there is reliable information regarding crimes involving nationals of a state party or crimes committed in the territory of a state party, the office of the prosecutor may initiate an investigation into the matter after obtaining permission from the pre-trial chambers. Thus, for instance, the ICC pre-trial chamber granted the prosecution authorization to open an investigation proprium motu in the situation in Kenya in 2010, culminating in the framing of charges against 4 individuals, including President Uhuru Kenyatta. Thirdly, the ICC may also exercise jurisdiction under Article 13b of the statute if the UN Security Council, acting under Chapter 7 of the Charter of the United Nations, refers the commission of crimes to the office of the prosecutor. Such a referral is binding in nature, and there is no necessity for the relevant state to be a party to the statute. This happened with regard to the situation in Darfur, Sudan, which was referred to the prosecutor in 2005 by a UN Security Council resolution. After a preliminary examination, investigation was commenced and arrest warrants issued against high-ranking civil and military officials. Similarly, the situation in Libya was referred to the prosecutor by the Security Council in 2011, has resulted in warrants of arrest, notably for Muammar Gaddafi and others, but that had mixed outcome and results. It is worth noting that notwithstanding provisions of Article 33 and 34 of the UN Charter that speaks of, that makes it incumbent upon the Security Council, as it deems, when it deems necessary, to call upon the parties to settle their disputes by peaceful resolution, as set out elsewhere and as I've referred to earlier in the UN Charter. Notwithstanding these binding provisions of the UN Charter, and as we can all see at the present point in time, the United Nations Security Council proceedings, wrought with political and strategic and diplomatic positioning, result in political exigencies invariably taking precedence over moral or legal, strictly legal considerations. Exercise of the power of veto on geopolitical considerations is still likely in the near future to get in the way of a favorable UN Security Council resolution over the Rohingya crisis and manifesting in a referral to the ICC under Article 13b of the Rome Statute. Of course, as I alluded to earlier, it is open for the ICC to exercise its jurisdiction if Myanmar lodges a declaration with the registrar of the ICC that it accepts the jurisdiction of the ICC under Article 12.3 of the statute. But I think we are all in agreement that it would be foolhardy under the circumstances to expect Myanmar to accept the jurisdiction of the ICC. But this remains theoretically an avenue for exercise of the court's jurisdiction and should be on the table for our discussion. To conclude, I would like to submit that as far as the Rohingya crisis is concerned, the most obvious route for exercise of jurisdiction by the ICC would be if A, Bangladesh refers the matter to the prosecutor for investigation under Article 14, or B, the prosecutor, proprium motu, initiates an investigation into the matter. The ICC Chief Prosecutor's request for a ruling on jurisdiction is currently pending with the pre-trial chamber, as we've heard earlier. A favorable ruling by the pre-trial chamber would, one hopes, pave the way for an investigation by the Office of the Prosecutor into the alleged crimes committed by the Myanmar authorities, ideally under Article 14 of the Rome Statute, putting the ball in Bangladesh's court. Thank you very much.
Thank you, sir. Ladies and gentlemen, now I'd like to request Ms. Kate Vignesoren, Consultant, United Nations Office on Drugs and Crimes and former ICC prosecutor on the Yugoslavia Tribunal, for her remarks. Thank you.
Thank you. I think I'll need to scroll through the screens. Is it possible to fill out that? It might be. It would be ideal, and then I don't have to signal every time I need to. Thank you very much. There we go. Good morning, everybody. I'd just like to thank the conveners for having me here today, for inviting me. I'm very grateful for this opportunity to speak to you about the application and to be on a panel with the other honourable guests. Thank you so much, Judge Ahmed. I think you've covered quite a lot of ground and saved me the trouble of covering it as well. There's going to be a little bit of overlap in the ground that we've covered, but I'm going to come at it from some different angles and highlight some of the more technical difficulties that this application raises. Being the lawyer that I am, I have prepared a PowerPoint presentation to guide you through some of the steps and the sort of technical components of the argument that the prosecution at the ICC has raised. It certainly helps me to visualise, and I'm hoping it will help you to actually see some of the language on the screen. Before I get into the details of the application, I wanted to just put it in context, and I think Judge Ahmed has done a very good job of already doing that with describing the crimes that have been committed against the Rohingya community in Myanmar, so I don't want to go through that again. One thing I wanted to just add to that is we shouldn't forget that the Rohingya are not the only victims of crimes in Myanmar, that there are other religious and ethnic groups that suffered through the attacks. There's a lot of debate going on at the moment about who's responsible for those crimes, which I think we don't need to get into here, but that this application, although largely focused on the Rohingya, also has potential implications for accountability for the crimes against these other groups. So the other contextual element I wanted to talk about was the purpose and intent of the International Criminal Court itself. Now, the court was established specifically to try these types of crimes. We had seen for the decades before the proliferation of other courts and tribunals that are very costly and were selective. And so the court was established to try and get around some of those issues and fill an impunity gap. And we can see that in the preamble to the Rome Statute, which talks about the most serious crimes of concern, about them not going unpunished, about ending impunity, and about the duty of every state to exercise its criminal jurisdiction over these crimes, and eventually resolving its resolve to guarantee lasting respect for the enforcement of international justice. So the concept of the court itself is based on this principle of complementarity, which is that states should exercise jurisdiction over these crimes. Every state that has a jurisdictional basis should exercise jurisdiction over these crimes, but where it's not willing or able to do so, the International Criminal Court will. So the entire model of the court is based on a diminution of state sovereignty, and that's what all of these courts do. So let's go to the application itself. There are three key issues that the application raises. I'm going to talk about two of them. The third one is around the process for making the application, the procedure that it should apply. There's virtually no guidance in the rules of procedure and evidence or the statute about this process, and it's something that Bangladesh may want to weigh in on in its submissions, or other amicus might want to weigh in on their submissions. There are some sort of due process issues there, but I'm not going to talk about those today. What I'm going to talk about is what is the nature of the crime of deportation under the Rome Statute, and what is the nature of territorial jurisdiction. So first, deportation, as Judge Ahmed's already pointed out, is a crime against humanity under Article 7.1d of the Rome Statute, as is forcible transfer. It's also a crime under the International Crimes Tribunals Act in Bangladesh. So Bangladesh has jurisdiction over deportation and a range of other crimes against humanity which have been committed. The elements of deportation are set out in the Rome Statutes, in the elements of crimes. This is where we understand what deportation actually means. So as there has been lots of discussion, the element of forcing a victim across a border is carried out in Bangladesh, arguably. But I think it's important to see how the elements play out. So the elements that are committed in the deporting state are that the perpetrator deported or forcibly transferred the victims. They were lawfully present in the area. It occurred without grounds under international law. It was part of a widespread and systematic attack on a predominantly civilian population, and the perpetrator or other actor had the requisite intent and knowledge. There's your border. Recipient state to another state or location. And this visualisation, I think, is helpful when we get to the question of territorial jurisdiction and what that actually means and when that kicks in. There's been a lot of debate around what another state or location means. And that's because it has implications for the scope of jurisdiction. Probably not in this case, but for other cases. So under customary international law, so that's the law being applied by other courts and tribunals, it means across an international border. Now, a border can be at sea, a border can be at land. So effectively that means anyone deported into the high seas has been deported. Anyone deported to another state has been deported. But the language in the elements is to another state or location. Now, some people connect deportation with state and forcible transfer with location. What that would effectively mean is that deportation only occurs when you transfer someone to another state's territory, but not to the high seas. This would obviously not accord with international criminal law, would leave a significant impunity gap. This is not something that the prosecution has really dealt with, but it is an issue that is being discussed, because the implication is if a person is deported to the high seas and then they make their way to another state, does that state have jurisdiction? Does that mean if that state is a state party, all of a sudden, because that person elected to go to that particular state, they can prosecute the crime, or the court can prosecute the crime? The prosecution deals with this, or doesn't deal with it, by talking only about direct deportation. So they say in their application they want to verify the court has jurisdiction where a person is deported from the territory of a state which is not a party to the statute directly into the territory of a state which is a party to the statute. And they repeat this language later on in their application, where they talk about deportation directly into the territory of a second state after crossing an international border. This is an issue that's come up in amicus submissions, one particularly by the Canadian Partnership for International Justice, who indicated that they will deal with this issue and whether or not deportation into another location would be sufficient. So I'm going to talk about territorial jurisdiction now and what territorial jurisdiction is. As the Honourable Justice has already set out, the application is based on Article 12.2a of the Rome Statute, which already indicates that sorry for the formatting, already indicates that one or more states might have jurisdiction over the same crime where it's occurred on the territory in which the conduct in question occurred. So what does territorial jurisdiction mean? Well, the traditional concept we all know is where a crime is committed on the state. That state has the right to exercise its criminal jurisdiction. But that has evolved over time. So we've got subjective and objective territorial jurisdiction, and as the Honourable Justice pointed out, the prosecution's application is based on the notion of objective territorial jurisdiction. Now, the prosecution has done a very good job of setting out the domestic and international basis for the exercise of objective territorial jurisdiction. It refers to domestic law, it refers to international law, and it refers to state practice, so through judicial decision making. Now, the exercise of that jurisdiction is not uniform. So some states say where the effects or consequences or results are felt on the territory, some say when one of the constituent elements occurs on the territory, some say part of the offence, some say a substantial measure, and it goes on and on. There's various different ways of describing it. And it's a spectrum. So some will exercise jurisdiction where none of the elements of the crime have been committed on their territory, but the effects are felt there. This is often used in anti-competition law, so where companies collude in violation of competition laws elsewhere and the effects are felt on the state, they will exercise jurisdiction, right up to where most of the elements occur. This makes sense, you know, we're living in a modern global world where people are moving across borders all the time, money is moving across borders, crimes are being committed across borders, and you can see this in terrorism cases, trafficking cases, corruption cases, and a range of other offences. So it really makes sense that the law is developed in this way. The question for the court, which I think is going to be a very difficult one for them to decide upon, is just where do they sit on this spectrum? The prosecution has put forward its position and it says no to effects-based jurisdiction. It says at least an element of the crime must be committed on the territory. So it sits somewhere around here. It says the crime must be committed in whole or in part on the territory. They've relied on this before. In another case, although there wasn't a court order on it, it was in relation to South and North Korea, where North Korea fired shelled onto a South Korean island, and they found that they had the right to investigate that, even though North Korea isn't a party to the statute. Now, I'm just going to go back. Sorry, why do they do this? Well, one, effects-based jurisdiction would be much harder to prove. It'd be much harder to show that there's an international law basis, or that under the general principles of law applied by domestic states, that this is actually a uniform practice. And they don't need to. If we go back to the elements, they don't need to. An element of the crime here has been committed in Bangladesh. And they have to, because if we go back to Article 12, it says the state on the territory in which the conduct in question occurred. So some of the conduct must occur in Bangladesh. If it's just an effect, I think it would be hard to fit that into the concept of conduct. So the question for the court is, how many of these elements? Is one enough? And there's also the question of which elements. Elements can be broken down into, you know, the acts of the perpetrators, the consequences of the crime, the intent and knowledge of the perpetrator. And this is obviously relevant here because the arrival of victims into Bangladesh is a consequential element. It doesn't. It's the result of the perpetrator's acts. The statute is ambiguous about what this notion of conduct means, because if we look at this provision alone, it says the territory of a state in which conduct in question occurred, or if the crime was committed on board a vessel or aircraft. It doesn't make sense for them to use different terminology, to use conduct in one sense and crime in another. they must mean the same thing. So you would imagine that they both mean crime and therefore all of the elements of the crime, but I'm not going to go through the detail. There's elsewhere in the statute and the elements where they interchange these terms. They also use conduct and consequence and differentiate between them. I think this is where the crux of some of the decision making here is going to get quite tough for the court. According to the OTP or the prosecution, the type is irrelevant. It doesn't matter. It can be a consequential element, it can be a conduct element, it can be a intent element. It's just as long as it's within the second territory. I wanted to flag some additional arguments that have been raised by amicus curiae submissions. We haven't seen the full extent of those submissions yet because they're not yet due, but some of the amicus in their applications for standing have indicated what they intend to argue. One is that deportation is continuing, that it wasn't complete or it didn't end at the time the victim crossed the border, that until those victims of deportation are able to return to Myanmar, to their homes, they're still being deported. So they're still being deported right now. They've argued deportation and other acts, so sexual violence, some of the other acts around the systemic discrimination of the Rohingya constitute apartheid and constitute persecution as a crime against humanity, both of which are continuing for the same reasons as deportation is. That sexual and gender-based violence and possibly deportation might constitute acts of genocide because the serious bodily and mental harm is still being felt while the victims are in Bangladesh. So these are all crimes that the court may still have jurisdiction over. And conditions of life calculated to destroy because the perpetrators intended to push the Rohingya into a situation in which they couldn't, they don't have livelihoods, and which they expected that they would be in a situation which would destroy the group. These crimes are still continuing. And as I've already flagged, deportation to another location is sufficient and not limited to another state. So what are the implications for ICC jurisdiction? Well, if the court says they have jurisdiction, just checking if I have time. 1 minute, okay. If they say they have jurisdiction, so they'll have jurisdiction over crimes where one or more elements committed on another territory is carried out. So theoretically, this doesn't have to be limited to deportation. It can be, as I've mentioned, cover things like genocide, cross-border killings, and any other continuing crimes that occur across the border. They'll have jurisdiction over other deportations into contiguous territories, so people have already been flagging the possibility that this might give a basis to exercise jurisdiction over deportations from Syria, for example, into contiguous states, in jurisdiction over victims who are in Libya who have been deported from contiguous states. It will not necessarily grant jurisdiction over deportation into the high seas, unless they get into the issue of indirect deportations, which I don't think they will. I think they'll limit it to the prosecution's application. I think the important thing for the court will be to set out some limits to prevent overreach of this principle. And this is done in domestic law all the time. They use a reasonableness test or other tests to ensure that the court isn't just exercising its jurisdiction to intervene where it shouldn't be. And there'll be other factors like gravity. So the court is, or the prosecution's not going to exercise jurisdiction unless the gravity requirement has been met. So for Bangladesh, I'm going to leave it to the Honourable Mr Ruddock to talk about the politics involved. I'm a lawyer, not a politician, but I do have thoughts on what this could mean for Bangladesh and what the implications are if jurisdiction is granted. Well, firstly, Bangladesh itself is in a position to prosecute these crimes if it can has the domestic law basis to do so, and the fair trial standards are met, so due process standards can be met in a way that satisfies the requirements under the Rome Statute. So if they get jurisdiction and the Bangladesh decides to prosecute, the court will defer to them. I think this could also, and I think there's obviously going to be a lot of debate about this, has the potential to defer future attacks. I think one of the things that we've seen since the late 1970s, where the Rohingya have been increasingly persecuted, increasingly attacked, and now almost all of the population has left and is in Bangladesh, is impunity. No one has done anything about accountability for these crimes. There have been various steps here and there, but nothing that's really been significant that actually has a deterrent effect. I think we all know, or from my understanding, Myanmar is concerned about accountability. And I think that this actually has the potential to really have that effect. And I think this is important for improving the humanitarian situation. I think you cannot repatriate these people to a situation in which they're going to be persecuted again. I mean, that's very clear under international law. And in order to facilitate repatriation, you need to have a situation in which they can actually go back. With no accountability, no pressure for them to change the systemic discrimination, the continuing perpetration of abuses, that's not going to happen. I was going to talk about Bangladesh's role in the development of international criminal justice, but I think the Honourable Justice has already talked about the Bangladesh framework sufficiently, so I'll leave it there. Thank you.
Thank you. Thank you, Ms. Kate Vignesoren. And now, ladies and gentlemen, it's time for remarks by our guest of honor for today's seminar, Honorable Philip M. Ruddock, Member of Parliament, former Father of Australian Parliament, and Mayor of Hornsby.
Well, thank you very much, Madam Chair. Can I acknowledge particularly Director Mansour Hassan, Justin Ahmed, Kate, our consultant, Professor Ahmed, and friends. It's a great pleasure to be here, and I feel greatly honoured that you have asked me to participate, but I must say you have me here under false pretences if you think I am in some way expert. I come to this role unable to correct anything that our distinguished lawyers have said. I have listened very carefully to the observations they have made, and particularly the importance of jurisdiction of the International Criminal Court, the extent to which Bangladesh may be able to seek to engage it, and the extent to which it can be undertaken unilaterally by prosecutors. We've heard Kate talk about the Rome Statute. I noted particularly in the observations she made that you can deal with deportation as a crime against humanity. You can deal with it. But when you look at some of the elements involved, I think they are particularly difficult to prove. The one that I focused on was that if you were going to deal with deportation, for instance, you had to be able to prove that the person was in fact a resident lawfully in the state. And you had to be able to show that the state knew, that's how I read it, that they were lawful residents. They sound like tests. I came here very much as a student. I may be a lawyer, I may have been formerly an Attorney General, I may have been a Minister of the Crown for some years, 40 years in Parliament. What it does is it gives you a degree of capacity to argue, but it doesn't make you expert. I'm not an expert on the law. But what I do know from what has been said is that if we're going to play any role in relation to getting these matters up before an international court and to have the perpetrators dealt with, we have to have the evidence. I want to spend a moment providing a little bit of context, if I may. I am a retired parliamentarian. Being a local mayor may give me some title, but I am a retired parliamentarian. I was involved for Australia as its special envoy for human rights. I have had a passion about human rights over all of my time in public life. I've been almost a life member of Amnesty International, a very worthy organisation that opposes the death penalty, that is focused on torture and seeks the release of prisoners of conscience. And I must say, they are issues that I have been pursuing all of the time that I have been involved in public life, often with great difficulty. They're not easy issues to deal with. But I want to see change. I had the opportunity as Australia's envoy for human rights to be able to argue that we should play a role in bringing a better understanding of human rights issues to the international community. And we were seeking election to the UN Human Rights Council and were recently elected to it, and in part my role helped achieve that outcome for Australia. I don't know how well we'll undertake the task, but one of the roles of the international community coming together in the Human Rights Council will be to get these matters up and argued. My interest in these matters may be one of the reasons I have been asked to participate. I had the opportunity of participating recently in a conference in Germany, Cologne, an organisation interested in these issues hosted a number of us to talk about these questions. And Professor was there with me, participating, as numbers of others were, in discussing the plight of the Rohingya people. I was better educated on these issues because of my presence, and I wanted to come to this point. If you go to the Cologne Declaration, you will find that it has statements about what is happening to the Rohingya, all of which I think in this audience you would endorse. But I found particularly a paper interestingly prepared by our then host Hassan of particular interest to me, because they spoke about what happened in Bosnia. And one of the points they were making was that, in simple words, Bosniaks as a nation have, since 1991, regardless of individual political, religious and other affiliations, documented uniquely and systematically in the best possible manner the genocide committed over them. Documentation was realised through the institutions as an immeasurable contribution to ensure that they were able to bring to account those who were responsible for destruction, murders and like matters. In other words, if you're going to go before an international court in the ways that have been described here, you're going to have to have documented all of the evidence in the most robust way. And if I were asked what could those who are here do that might help, it would be to play a part in helping to document the information that is going to be needed to bring these matters forward. I thank the Dakar University, I thank our Genocide Centre, I thank ActionAid because they've made it possible for me to be here. But what they did was they also made it possible for me to visit Cox's Bazar. You might think for a politician, this is a unique experience. It's not for me. My first visit to refugees started when I saw Afghans in Peshawar in the early 1980s. I visited the Vietnamese, whether they were in Malaysia, Hong Kong, Indonesia, fleeing after the change of regime there. I saw many of the Khmer over a long period of time. I visited Africa. I was responsible for putting in place the first programs to bring southern Sudanese to Australia when I'd visited the camp at Kakuma. I spent time particularly in the Balkans. I did visit Bosnia. I saw the Serbs who had fled Croatia. I've had the opportunity of visiting extensively in the Middle East. I'd recently been in Turkey, in Jordan, in Lebanon, to see the people who had fled the horrific circumstances there. I visited the camps. I saw what there was to see. I have to tell you, none of them are ever very pleasant places to be. There is no way that people should be left in circumstances like that. And I found Cox's Bazar every bit as bad as anything you could see, notwithstanding the enormous effort that is being put in by well-meaning people to help those who have fled. When I saw something of the 50% of children that the judge referred to, and I looked into their eyes, I bonded with them, I saw them and listened to them, denied even there a full and effective education system for all the work that is being done. I'm taking home to show to all that I can the photographs of these magnificent children in this most depressing environment. But I wanted to share with you something of what I see as the hopelessness of their situation and what is likely if we don't address it. My first visit to a difficult political situation occurred in the 1980s. I went to Sri Lanka for the commemoration. They were a Commonwealth country. Bangladesh is a Commonwealth country. They had their independence and we were celebrating the 50th years of the, I think it was, of the Commonwealth Parliamentary Association. A great celebration, the rule of law, independence. I sat down with people of different backgrounds. Sinhalese, Tamils. When I sat down with the Tamil community, I heard about their concerns. Look, there had been circumstances that people would have said was colonial and terrible because the British used to divide and rule. They would advantage some over others. And the Tamils were seen to have been given an advantage in education and employment opportunities in government over the Sinhalese population. I mean, that's the background to it. And yet, at a very time when people could have sat down and constructively worked out the way in which if you have a different religion, you have different cultures, you have different interests, you can function effectively in a unitary state because you allow people to keep their heritage, to keep their religion, keep their language, and still function effectively within the state. And at the very time when they could have worked those issues out, established some municipal governance and allowed these differences to function effectively within the concept of a continuing nation, they refused to come to any agreement. It was possible. And within a short while, you had the establishment of the Tamil Tigers. and you know the tragic loss of life, the internal disputation that has gone on and on and on because those issues weren't addressed. Look, in part of my last life, publicly in Australia, I was asked to chair a panel that deals with religious freedom. It prompted me to look very closely at the international law, which all nations say they are party to. All nations. The Universal Declaration on Human Rights, to which every nation signed, is a starting point. I know there are some who say if you tried to get the world to sign up to a Universal Declaration on Human Rights today, it wouldn't be possible. There are some who do say that. You've got the International Covenant on Civil and Political Rights. And in Australia, we're party to it. And it guarantees freedom of thought and conscience and religion. It says that everyone shall have the right to freedom of thought, conscience and religion, and this right shall include the freedom to adopt a religion or belief of choice, individually or in community with others, in public or in private, and to manifest that religion in belief and in worship. And no one shall be subject to coercion which would impair this freedom to have or adopt that religion or belief of choice. Freedom to manifest one's religion and beliefs may be subject only to such limitations as are prescribed precisely by law and necessary to protect public safety, order, health and morals and fundamental rights and freedom of others. And in those states in which ethnic, religious and linguistic minorities exist, persons belonging to such minorities shall not be denied the right in community with other members of their group to enjoy their own culture, to profess and practice their own religion, or to use their own language. I make these points because they are part of the international framework of law that is of fundamental importance if we're going to be a civilised society. And in Australia, we don't regard ourselves as being perfect. We're not. There are always individuals who may occasion some difficulties with whatever values you adopt. But as a state, we affirm people's rights to make choice in relation to those matters. They can be part of a unitary state, but maintain their culture, maintain their language, maintain their religion. And I often say in Australia that diversity is a choice and a strength, because we've shown that people of every faith, all the world's cultures, can in fact live together. Most people don't understand that Australia has 25% of its population overseas born, and people who have come from all over the world. I say it's not perfect. It's not. But we've been able to demonstrate that it can be made to work. I think sometimes bicultural situations are more difficult and more challenging because people feel threatened. And that means I think there has to be a little more work. But I guess in coming to this seminar, I wanted to hijack it. I wanted you to understand the importance of the law. And all of the explanations that have been given are of fundamental importance for marshalling one of the weapons that we need to put together to produce change. I want to see the law used to get a better outcome so that the Rohingya can go home in safety and in dignity to be able to rebuild their own lives. When I spoke at Cologne, I took the opportunity to say to all of those present the international community has a responsibility to ensure that the regime in Burma changes its modus operandi. Now, I don't believe it's all that difficult. They hold themselves out to be a form of federation. There are differences. And I recognise that, you know, if you look at the Burmese having probably only 40% of the population, they've got 60% that represent diverse minorities. They're not Rohingya. A number of minorities, and they've got to be able to put in place a regime that is going to ensure that they're going to function as a state. I don't think, and I've said this, I've spent a lot of time in Africa, I don't think redrawing boundaries is going to be all that possible. I don't think we're able to go into Burma and split it up and say, well, we'll have a Rohingya state here and we'll have a Karen state there and break up the nation. I mean, I think there are sound political arguments for saying if you want to maintain a unitary state, you have to look at the models that enable you to provide for all people to function effectively, exercising all of the fundamental rights in which we agree. And I would hope that as well as the legal system being used, we will marshal the political states to put pressure on Burma to change. I think, and I got the clips which could reinforce the arguments I'm about to make, I would like to think that the world community that has recently visited Bangladesh through the Security Council has gone to Burma and has seen and heard from some of these people that they will have a desire to use the capacities and powers that they have to put pressure on that regime to change. In my view, sanctions effectively put in place universally have had some impact on North Korea. It's still working its way through, but we've got people to the table talking about these issues because sanctions have played a part. In relation to Iran, still working its way through. President Trump has different views about how these things might be addressed to his predecessor. But again, sanctions produced very significant change on major political questions because Iran realised that if it was going to be an open trading economy, it needed to engage with the rest of the world. My view is that the change that could occur if the UN were prepared to use sanctions in the same way could be substantial and would be quick to deliver outcomes. But you need to have Russia and China on board. And I know what the difficulties are. The Belt and Road strategy of China is about engaging with Burma, and so they see the regime as being important for their future trading into the Indian Ocean. I mean, I understand that's part of the psyche. I'm not against them achieving trading opportunities. I'm not against them being a powerful trading nation. I'd like to keep taking them on and working with them in relation to enhancing opportunities for their people and ours. And I would like to think the same would be the case in Burma. I mean, when you think about it, it's a state that needs to engage with the world community if it's going to be able to deliver for its own people all of the opportunities that we have seen others successfully achieve. And so I come to an occasion like this. I hope you will forgive me if I've hijacked the venue and the event. But I am strongly of the view that we should use the international law because it's one of the levers. But we ought not to forget that there are a multiplicity of leaders that need to be used. And for those children I saw, for the families I talked to, this matter needs to be resolved, and sooner rather than later. Thank you very much.